Counselors, the jury wants to see exhibits that were not introduced during the course of trial. You want to know what I'm going to do? Come join me for a moment as I share with you what the judge is in all likelihood going to do in this instance. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now we've gone through the entire trial, whether it's an accident case or a medical malpractice case or even a wrongful death case. And now the case has gone to the jury, and we're waiting for the jury to reach a conclusion about who is more likely right than wrong. Now the jury sends out a note to the judge. Judge, we would like to see the exhibits. And now they identify which exhibits they want to see. The judge takes a look, calls up the attorneys, and says, listen, these are the exhibits the jury wants to see. And it becomes very obvious that these particular exhibits were never introduced into evidence. Instead, they were simply used during the course of questioning various witnesses, but were never used specifically to introduce into evidence. They were used to illustrate and to show to the jury what it was that the expert was talking about. Can we give those exhibits into the jury so now during their deliberations they can go ahead and use them to come to their conclusions? The answer is no, we can't. We cannot give the jury those exhibits specifically because they were never introduced into evidence. Now, should they have been? In all likelihood, they should not have been. Why? Because we use exhibits to illustrate certain things that our witnesses and our experts are talking about. And in many instances, there's no specific reason to use an illustration to get that into evidence. So now, if the jury wants to see that particular exhibit, and that has not been introduced into evidence, the judge will not permit that particular exhibit to go into the jury room. And the jury may be really upset. They may say, Judge, we'd like to see those. And what the judge will tell them is, listen, this has never been introduced into evidence, and the only things that you are permitted to take with you and review and analyze during the course of your deliberations are items that were introduced into evidence. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what happens during the course of trial when the jury turns around and says, Your Honor, we would like to see certain exhibits even though they were never introduced during the course of trial. You know, I recognize you've got questions or concerns about your own particular problem. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit and you have questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.